Buenas and Hafa Day. The Committee on Health, Tourism, Historic Preservation, Land, and Justice is now called to order. Today's Wednesday, December 11, 2019. The time is 12:05 p.m. Notices for this public hearing were disseminated via email to all senators and all main media broadcasting outlets on Tuesday, December 3, and again on Monday, December 9, 2019. The notice was also published in Guam Daily Post on Wednesday, December 4, and Friday, December 6, 2019. There are several agenda items on today's. At 12 o'clock, we are going to hear two bills. Bill number 124-35 LS, sponsored by Luis Borja Muña, an act to amend Section 5106A of Chapter 5, Title 19, Guam Code Annotated, relative to permitting the automatic certification as adults for minors under the age of 16 charged with the crimes of homicide or criminal sexual conduct. The second item is Bill number 206-35 COR, sponsored by Luis B. Muña, an act to add a new Section 25A204 to Article 2 of Chapter 25A of Title 9 Guam Code Annotated, relative to creating the offense of production of child pornography as a first-degree felony. At 1 o'clock p.m., we will have an oversight hearing on the Chamorro Land Trust Commission to receive status updates on the litigation, commercial collections, and residential leases. I'd like to acknowledge the presence of my colleagues and thank them for being here. Senator Kelly Marsh Taitano on my far left, Senator Tello Taitagui on my left, and Senator Luis Borja Muña. Thank you, Senators. All right, so we'll proceed to the first agenda item, which is Bill number 124. And I'd ask the sponsor to introduce the bill. Senator Muña.
Thank you, Madam Chair. Since 1972, the case of the people of Territory of Guam versus Lefevre has provided the rule of law that the court of jurisdiction over a criminal case is a court of jurisdiction at the time that the case is charged, so long as the time that passed since the crime was committed was still within the statute of limitations. The Lefevre case has been cited at least 8 times on motions to dismiss based on jurisdiction. At each time it was upheld. The Lefevre precedent was settled law until 2017. Then the Supreme Court of Guam issued opinion number 2017 Guam 13, which addressed this issue of jurisdiction but did not address the Lefevre case. The question in the appeal was whether the defendant should have been given an adult sentence since he was a juvenile under 16 at the time the crime was committed. Instead, the Supreme Court departed completely from the motion in the appeal and ruled on the case based on jurisdiction. It ignored the ruling in the Lefevre case and instead looked at the family court statute in Section 5106 of 19 GCA. The Supreme Court decided that the legislature intended that the court of jurisdiction for crimes committed by juvenile defendants is the family court and not the superior court. The 2 exceptions are, 1, when the charge is homicide by a juvenile 15 years old or younger, or 2, when the charge is a first or second degree felony committed by a juvenile 16 or 17 years old. In this case, the defendant was charged with second-degree criminal sexual conduct as a first-degree felony, to which he pled no contest. He was 13 and 14 years old when he committed the crimes. Because of his age when he committed the crime, the Supreme Court determined that the Superior Court did not have jurisdiction to accept the defendant's plea and that proper jurisdiction rested with the family court. Subsequently, the Supreme Court reversed the plea agreement and vacated the defendant's guilty verdict. Prior to 2011, homicide was the only crime with no statute of limitations in 2011. The statute of limitation was repealed for felony charges for criminal sexual conduct. The defendant in 2017 Supreme Court case was an adult at the time he was charged, but was a minor at the time of the criminal acts. This ruling by the Supreme Court leaves our justice system with 2 completely opposite rules on jurisdiction. The one in Lefevre is the other. The one in the Lefevre is the other. Bill number 124-35 proposes a couple of things. One, to add criminal sexual conduct to the categories of crimes for which juveniles under 16 years old can be tried as adults. And two, to give the Superior Court of Guam jurisdiction for criminal sexual conduct crimes committed by juveniles under 16. The intent of this bill, Madam Chair, this Bill 124, is to reconcile these conflicting rulings, Lefevre and 2017 Guam 13, so they don't result in a victim being denied justice in the future. The bill is a first draft that we will seek the input of the Attorney General's office to ensure that the final language is fair and workable. And I believe, Madam Chair, we did get a letter from the Attorney General. Would you like me to acknowledge that? From the Office of the Attorney General. With our meeting we had with them yesterday. As discussed with you and the staff, our office is in support of the efforts Bill 124 aimed to achieve. As we also discussed, our office will not submit written testimony by tomorrow's public hearing, which is today, but we remain open to working with your committee and office to develop these measures in anticipation of providing testimony at a later date. And this is from the Office of the Attorney General. And that's it. Thank you, Madam Chair.
Thank you, Senator Muña. For the record, the committee has requested the feedback of the Office of the Attorney General. Testimony, according to the Attorney General, is forthcoming, as well as we've requested feedback from the Public Defender Service Corporation, the Guam Behavioral Health and Wellness Center, the Director of the Department of Youth Affairs. And now, I guess I can open it up to our, there's no one listed to testify, so if any of the senators have any questions or comments, Senator Kelly Marsh-Taitzino.
Sejus Masi, Madam Chair. I do have some questions, and I was really hoping that there would be somebody here with that sort of background that would be able to answer them. But what I can do, if needed, is to place them perhaps in the form of a letter and ask them to get some answers. But one of the things that came across my mind is that if we're talking about specific crimes, there being two, homicide has already been in the books as someone who is being a minor, that they are automatically considered an adult, and then this is adding in those criminal sexual conduct. And so it seems to me that there may still be some level of crime that is still within that loophole. I tried to do some research on it, and it seems that for lesser offenses, we wouldn't be alone in this case, but that there do seem to be loopholes, and so that seemed concerning. And then wanting to know the differences in trying someone as an adult versus a minor in cases such as these, and wanting to hear from those that are serving in Guam in these capacities, whether there's a difference in rehabilitation or recidivism in convicting someone as an adult versus a minor in cases such as these. In doing a little bit of research, some of the concern, and I'm sure the other senators here have looked at that as well, is that being tried and convicted as an adult, that there may be fewer opportunities for rehabilitation and they may come out as a harder criminal. But I think Guam has its own set of particular data that it'd be good to hear from someone within our system. So I very much appreciate that the chair has written to entities like the Department of Youth Affairs and others so that we can perhaps get some of this feedback. And our victims and the public better served in trying and potentially convicting someone as an adult versus a minor in cases such as these. Of course, we're here for the better interest of the victims and the public. And so not only how is it affecting and impacting the person who has committed this crime, but wanting to make sure that it is indeed serving the victims and the public better. And wanting to find out if there are other ways that this loophole can be closed, just so that we get a full spectrum of possibilities. Yeah. Thank you for letting me pass on those concerns.
Appreciate those. They will be under consideration by the committee. Senator Taitakwi?
Thank you, Madam Chair. Madam Chair, yeah, as well, I was hoping the Attorney General's office would be here, and but not only the Attorney General, but I'd like to also hear from the judicial branch if there's been any reach out to the judicial side. I've noticed in the physical note that was provided, and BBMR is unsure of any costs, but they are also at the forefront too when prosecuting these cases, and I think their opinion would also be very helpful in maneuvering this bill. But I thank you for the opportunity and look forward to hearing from both branches, and as well as DYA, which is also a very good place to start as far as researching their opinions. And appreciate it. Thank you so much.
Thank you. I wanted to note also for the record that we've received some comments from our legal bureau here at the legislature in regards to line 3, page 1. They recommended referring to the Guam Supreme Court opinion itself rather than interpreting the same, so as to prevent any confusion in interpretation of the case law. On page 2, line 18 of the bill, in reference to Public Law 31-7, removing the statute of limitations for criminal sexual conduct crimes, our legal bureau recommends deleting this reference, as Public Law 31-7 does not remove that statute of limitations for criminal sexual conduct. Legal also recommended providing a reference to the language or deleting lines 19 to 22 on page 2, which currently states, quote, that the statute of limitations for other criminal sexual conduct crimes extends beyond those of other criminal offenses, including offenses that allows victims to file a complaint for up to 3 years after they turn 18. Per legal, it is unclear what actual crimes are referred to here and how other criminal sexual conduct crimes, as compared to, quote, other criminal offenses, are relevant to this particular bill. So these are pretty much technical corrections that hopefully with the sponsors' help we can address in these bills. While the intent of this bill is to address a gap in the law with regard to jurisdiction, I am also concerned, just like my colleague, with the removal of the family court judge's discretion and what impact that would have on the rehabilitation of minors or offenders in the juvenile justice system versus in the adult court system. If we're speculating, or I'm speculating, but I would like to know what actual impact that may have on whether there's any chance that they will have rehabilitation or not. The bill intends to give the discretion to the Superior Court, not the family court, as to it kind of automatically certifies these minors as adults for these crimes, and this is a big departure from the current system, which keeps these cases confidential in the family court system and allows this family court justice to determine whether it can be certified as the minor can be certified as an adult for this crime. I know that in an ideal system, both adults and minors are going to be given chance for rehabilitation and treatment. But I think that we've seen with the roundtable hearings that we've been having in my committee that there is a lack of such treatment for adults especially, and that there are some available currently for minors, and I guess I just want to make sure that we don't preclude anyone who can take advantage of this rehabilitation or treatment from getting the services that they need, especially at those young ages. It's not clear to me, and I'm hoping to hear from these agencies why they believe one court is better suited than the other court to determine, whether they should rule on this minor, or they should retain jurisdiction of this minor. Again, I wanted to clarify with the Attorney General whether minors being certified as adults would be detained immediately after arrest in DOC or DYA. And I think, there's been some discussion of that, but that needs to be clarified. And again, this is because I'm sure they're going to have a very different experience, depending on where they are placed immediately. I'd like clarification regarding how this bill would impact the following scenarios, including minors under the age of consent engaging in consensual intercourse, or minor victims of sexual abuse who commit sexual crimes. Those are just some of the questions that I'm hoping the Attorney General's office can help us to clarify, and I know that the sponsor is also working with them and others on this bill. So would you like to close on the bill, Senator Muña?
Thank you, Madam Chair. Now, I'm not going to discuss anything in regards to the AG's opinions, but just to address some of the concerns with the panel here today, that I too also had some concerns about whether if an adult who committed a crime as a juvenile gets tried as well to the rehabilitation that's recommended from either the family court or the superior court is conducive to the age of the person who was tried and convicted. So those were some of the things that I had questioned the AG's office as well. And then also about if they are convicted as an adult, but the crime was committed when they were a juvenile, how do they manage what the rehabilitation is? So that for me, that was part of my concern as well. And even the vice versa, if a juvenile is convicted as well, they don't automatically send them to DOC. They're housed at DYA until such a time they become adults too. So I did have a lot of questions as well too as to how the concern is. And it also would be nice if we could get that request from Guam Behavioral Health and see how they manage with that too, if we can get that in the committee report and make a request for that. And we also did discuss the opportunity to keep the cases sealed up until the time that it could possibly be referred back down to family court rather than staying at the Superior Court. So those were some of the things that we discussed. I know the conversation will continue, and we will work with you, Madam Chair, and the committee, and then as well as the AG's office and all the other agencies to make this a much better law to protect the victims, the young victims. That's really the whole intent of this, is to fill up that loophole, and I think even the AG was in agreement that there are loopholes in this particular law. So I look forward to working with the committee on that. Thank you, Madam Chair.
Thank you very much, Senator Muña. There being no additional individuals to present testimony, this committee will continue to accept testimony until December 20 on this bill. And we will move on to the next item on our agenda. The second item is Bill number 206-35, also introduced by Senator Luis Muña. And you would just ask the Senator to introduce the bill. Thank you, Senator.
Thank you, Madam Chair. Bill number 206-35 is an act to add a new subsection 25A204 to Article 2 of Chapter 25A of Title 9, Guam Code Annotated, relative to creating the offense of production of child pornography as a first-degree felony. Bill 206-35 makes the manufacturing of child pornography a crime. When Public Law 29-63 was enacted into law, it made the possession and distribution of child pornography criminal offenses. It also made enticing a child over the internet for immoral purposes a crime, but it did not address the issue of manufacturing or producing child pornography. The bill does not make any photographing of a nude or semi-nude minor a crime. It is very specific in its elements that require the subject to be portrayed in a sexually explicit nature or are sexually explicit themselves. The bill also makes the use of hidden cameras where a minor is photographed or videoed in the nude without his or her knowledge a crime of manufacturing child pornography. We currently have laws that are enforced to punishing, sexting, or sexually explicit images of minors, but unless the photographer is found to be in possession or distributed the images, then there is no crime to punish him or her for child pornography, even if the child testifies against the photographer. It is my hope that this bill is enacted so that Guam can join all the states and territories in making this practice a first-degree felony. Thank you, Madam Chair.
Thank you, Senator Muñoz. For the record, again, the committee has requested feedback of the Office of the Attorney General, the Public Defender Service Corporation. There is no one signed up to testify on the bill, so I'm going to open it up to the panel again. If there are any questions or comments by Senator Kelly Marsh, Taitsino.
Madam Chair. And again, I really was hoping that there would be people here who could provide answers to questions that I have. We're dealing with very important issues. We're dealing with very sensitive issues and ones that need to be looked at very carefully and guided by professionals who understand these issues, not only in general, but as they affect our Guam population specifically. So again, I hope that we can put forward these questions and retrieve some answers prior to further consideration of the bill. So with this, I am interested in getting updated statistics of sexual abuse or assault on minors on Guam. I think this could be very telling. I think right now we probably don't have any statistics about the potential of minors being affected by what would be classified as pornography. And I think these kind of statistics would be very telling as to what kind of a situation we are potentially dealing with and how much of an impact we could be making with this. Of course, the numbers, in a sense, saving one person is important enough, and serving as a deterrent, hopefully, is important enough for this to potentially go through and be approved so that we're better saving and protecting our minors. And one of the other things that came to mind as I was reading through this was whether there would be an age distinction about those producing the material. We're hearing nowadays about, unfortunately, kids who sext, are involved in sexting, and who might be caught up for one reason or another in these sort of activities. And so we might consider whether that's important, or to hear from experts on if there is an important distinction between how to respond to these different ages that are involved in this type of activity. The other was, it was unclear to me whether this applied in the same way or should apply in the same way if it is self-produced material. So certainly we want to keep any minor from being involved in this in any way, shape, or form. But again, there might be, from the professional perspective, they might give us some guidance as to if someone is self-producing this, then there may be deeper rooted issues. Well, there are probably deeper rooted issues no matter who's involved, but there may be deeper rooted issues that rather than having to be a first degree felony for somebody who is a minor or even somebody around that age, it'd be good to hear from the professionals as to whether counseling or some other sort of approach would be more useful. From what I've read over the years, for the young that are involved in this, and I assume it's changed a bit, we have so much explicit material all around us, commercials, TV shows, and movies. It's almost ever present nowadays. And so some of it could be attributed to that. But for a lot of individuals, it's attributed to the fact that they've been abused. And so if it is indeed because somebody has been abused and they're acting out in one way or another, another approach, instead of being considered having carried out a first-degree felony, that might be important to consider. So again, those same entities that the chairwoman had spoken about reaching out to, hearing from DYA, hearing from the Guam Behavioral and Wellness Center, I think that those are going to be very important groups to hear from as well as others. But those were just some of the thoughts as I was going through this. And I also wanted to add in here that there is, throughout the bill, the reference to sexually explicit, but I think even just the look of or the action of, whether clothes are on or off, inappropriate touching, inappropriate actions such as that, I think that that needs to be there so that there are no gray lines for somebody to try to get around the real intent. And I'm sure that's part of the real intent of here, is we're here to protect them on all accounts. So I'd like to recommend looking at language like that so that we've covered those kind of inappropriate and sexual in nature type of actions that could happen to kids that we want to be avoiding. So just Masi for allowing me to provide comments again.
Thank you, Senator Taitsino. Senator Taitsigui? All right. Again, Senator Munoz, would you like to close on the bill?
Yeah, just very briefly, thank you, Madam Chair, and thank you to my colleagues for their suggestions. I look forward to working with the committee and all of our colleagues and the stakeholders, of course, like the behavioral health and everyone else, to make this bill a law. Child pornography is actually made worse by the existence of the internet now and technology, and making it just so much easier for that to happen. I feel that we should punish those directly who abuse children to perpetuate this kind of crime. Thank you so much, Madam Chair.
Thank you, Senator Munoz. There being no additional individuals to present testimony, this committee will continue to receive testimony on this bill, 206-35, until December 20th, Sizus Masi. So we're going to conclude this portion of our hearing. We are going to reconvene at 1 p.m. for the oversight of the Chamorro Land Trust. Sizus Masi. Thank you, senators, for being here. Sizus Masi.